The only thing I have a story to share here. We're going to go to Nick Freeman, who you may know as Mr. Loophole. And my story is as follows. I remember being pulled over in Liverpool by a transit van, a police van. Like we used to call them Black Mariahs. So it was a riot van. And this guy pulled me over and he said, you were speeding. I think he said I was doing 38 and 30 or 36. I can't remember. And I knew that, hang on, pal, you need to really demonstrate that your speedometer, first of all, has been tested that day. It's accurate. And do you have a witness that can tell you I was doing 38 and a 30 or 36 and a 30? And so I was just listening to what the officer was saying. He was quite a cocky guy. And I noticed that he had a passenger in the car. But the passenger wasn't in police uniform. So I said in passing, oh, is that a fellow officer? And he said, no, he's a civilian. And I'm taking him back to the Nick. And at that point, I thought, hang on, it's just your word against mine. And more importantly, it's your transit van speedometer against mine. And I contested it. And it was thrown out. Let's go now to Nick Freeman, a pal of the station. We're lucky to have him. Mr. Loophole. Good morning, Nick.
Morning, Danny.
What do you think about my little story?
Well, it's a good story, and it was the right result. The van, the transit van, the Black Mariahs they were in those days, it wouldn't have a properly calibrated speedometer. And to convict you, they obviously would have to measure your speed over a distance. They'd have to comply with the guidelines, and there'd need to be collaboration. So for a whole host of reasons, I mean, he was on a wing in a prayer, and you stood up to him and stood up to the system, and you rightly won. And you were always going to win if you stood up. I think what they rely on sometimes is people who are intimidated and just roll over.
Of course.
These statistics show that 20%, 1 in 5, it's an astonishing number, isn't it, in your area that have successfully challenged these. This is before court. This is just a fixed penalty notice. It's astonishingly high. And I don't know what the breakdown of these figures are, but there would appear to be a huge difficulty in remembering who was driving or in the police establishing who the driver was. That, of course, is a problem because the system, this robotical policing, is dependent upon people being honest. I'm not suggesting your listeners aren't honest, but it's dependent upon people being honest and complying with the notice that's sent to the registered keeper as to who the driver is. And
okay,
if that system breaks down, with the lack of resources that currently exist with the police, it's very hard for them to prove otherwise. And I note from the article in your local newspaper that appears to be one of the main reasons why these matters are successfully being disbanded.
Okay, now people listening would think that speeding motorists are getting away with impunity here because they know how to play the system. What would your response be to that?
Well, look, it's a massive number, isn't it?
Yeah.
It's a huge number. 57,000 is a huge number, but 12,000, this is before court. This is people dealing with it themselves. And I'm sure, my guess is that the registered keeper receives a notice within 14 days. I find it very hard to understand, unless there are exceptional circumstances, how the registered keeper doesn't know who the driver is or can't remember. And the main problem appears to be here, the difficulty in locating the driver or establishing the driver. And I think what many people don't realise is they think, oh, it's £100 and 3 points. If I say something that isn't, if I say, I just can't remember, and you know who was driving, that bit of information I can't remember is actually perverting the course of justice. And if the police had the resources to prove who was driving, that the person who relayed that information would probably end up going to prison for perverting the course of justice. But of course, the police have got bigger fish to fry at the moment, and this is at the lower end of the scale. And I think it may be that people are taking advantage of the lack of investigation that currently exists. And
that is so interesting, Nick. So if they genuinely can't remember, I mean, that would be maybe a mum or a dad, and they couldn't remember whether they were picking up the kids from school that day.
Yeah, but look, we all have busy lives. The notice goes, you receive it. The maximum period it's received within 14 days. It should be okay. It's very hard, really, isn't it? To if someone said to you, "Well, what were you doing 12 days ago or 10 days ago?" You'd put your mind back and you think, "Oh yeah, no, I remember I was doing this. I was on that particular road at this time." There are other problems with it, and apparently some of the notice of intended prosecution have wrong information on. That's just sloppy prosecution. But the vast majority would appear to be establishing who was driving or not being able to locate the driver. And that sort of sends a loud warning bell up to this prosecution system and robotical system. Because, in days gone by, a police officer will pull you over, he would identify you, and you would be that person. There would be no doubt as to who was driving, provided the police establish your correct credentials and details. But now, of course, we're in a different world, and 57,000, it's the highest number, I think, since 2013. It is dependent upon the integrity of the motorist and the driver, dealing with it honestly and fairly. I'm not saying they're not, I'm just saying it's a very high number.
Sure, and these are typically would be speed cameras or the enforcement vans that you see, Nick.
Yeah, these are all cases. The vast majority are cases. The vast majority are cases where people are not stopped. So the registered keeper receives a notice. It's called a Section 172 notice. It has to be received. The notice of intended prosecution part has to be received within 14 days, and you have a legal obligation to nominate the driver. And I think that's where the system is breaking down.
If the letter didn't arrive within 14 days, but it did, but you just binned it and you told them that it hadn't arrived, would they take that, or would they just assume the assumptions that it...
I would very strongly urge your listeners not to do that. That is perverting the course of justice. You know what happens is, people do that, and it's good dinner party talk, isn't it? And then someone thinks, I don't like that person, and they go and report him.
They fall out
and
with
the number
someone,
of people who have, because you do something like that, you're not likely to keep quiet about it. And you're going to tell somebody, and you're then in the trust of that person for the rest of your life. And I've seen the fallout, and it isn't worth it.
In fact, wasn't there an MP?
The NIP, it's a very complex area. I recently argued a case in front of a judge. There was 6 hours legal argument just in relation to the notice of intended prosecution. That was the only argument. It was 6 hours in front of a judge. It is very complex. But the basic rule is it has to be received within 14 days. And there is a presumption, if it's sent by first-class post, that it has been received and that it arrived on the second working day.
Nick, just finally, you mentioned about lying, about perverting the course of justice. And wasn't there 2 or 3 years ago, I can't remember the name of the MP, but she covered for...
Chris Hume and Tracy, Vicky Price.
That's it. And they ended up having a divorce, and she actually went to prison because she was so... what's that word about a woman's scorn? I can't remember the expression. But she actually, she put her husband in the frame. I think they both went to prison. They both went to prison, yeah.
And the ironical thing about that case was the notice that they lied about was actually a defective notice. And had they received advice from a lawyer who knew what he was talking about, he would have been able to explain that actually the notice didn't comply with the particular requirements. And had it been dealt with properly, they would have had nothing to deal with at all. But they took the law into their own hands, thought they knew what they were doing, and got it wrong and paid a massive, heavy price.
Didn't they just? Nick, thank you for your time. Last time I spoke, you were cruising down the auto route in your fabulous sky blue Bentley convertible. And you were telling me that you were thinking of selling it.
No, I've still got it, Danny. I'm not selling it. I'm going to keep it. I'm keeping it. It's a beautiful big beast.
Oh, no. Okay. Nice to catch up again, Nick. Thank you.
Well, cheers, Danny. Bye-bye.
All the best, mate. Good lad.